Yeah, I mean, I like that. I really do like that.
Okay, we're back here, we're back into session. And I would just like to state that after we did adjourn, I asked Mr. Willard to get for me the Chesapeake case so I could look at it. And he then went to Mr. Geddes, who confirmed that I had already stolen the right case from his desk. Actually, Mr. Willard borrowed it from his desk, so I don't know if anybody has any objection to that, but I had in fact read, again, part of that case. And the primary decision we had to make is whether or not the examiner, the hearing examiner, applied the right legal standard. And under public utilities, in the case that was both parties have talked about, all the parties have talked about, it talks about operating expenses, and I'll just quote from the case. For purposes of rate setting, public utilities operating expenses are generally defined as those expenses inherent in cost of producing utilities service required to keep the utility running. They are the expenses normally incurred in the course of the utility's ordinary activities. It may include maintenance and repair, payroll, insurance premiums, taxes, paid legal expenses, collection costs, and advertising fees. Now, there is law indicating, there's further law, which I'm not going to get into because I don't believe it's necessary, but the word that, to me, that is pretty significant in that which I just read is the word normally. To my way of thinking, there was an expectation that those batteries were going to work as ordered and contracted, and that their failure was, in my personal opinion, an extraordinary event or factor and not a normal operating expense. I think reasonable people could differ with respect to that comment. So I would just like to have my fellow commissioners express their opinions or ask questions and see if we can then come to a motion and resolve this matter. Commissioner Gray.
I think as the testimony is borne out, the contract was signed with the supplier. The expectation was created or contractually asserted that the batteries would function for 10 to 15 years. And so I'd have to agree with the chair that the fact that there were reasons to replace the batteries after approximately 5 years, if I read it correctly, would be an abnormal, unordinary occurrence, which might lead me also to conclude the expenses were extraordinary.
Commissioner Correa?
I also agree with the chair on that concept that this was an extraordinary event, an extraordinary expense to rectify the event by buying the new batteries, and therefore this is an extraordinary expense.
I agree this is an extraordinary expense, and it doesn't incorporate or it doesn't take into account the fact that this may have given 15 extra years or extra years time for which batteries would not need to be replaced, and there would be expenses incurred. I mean, but that's not what they're asking. That's not what we're opining on here. I mean, these are expenses that were incurred perhaps prematurely before the failure of some of the batteries. However, it doesn't change the fact that it was extraordinary, given the 15-year life expectancy of the batteries and the cost to change them before that 15-year period was up.
And I would agree with my fellow commissioners that because the life of these batteries were to be 15 to 20 years and things went wrong much earlier, that this was an extraordinary expense.
To the parties, assuming we make a decision, which obviously we're going to make here in the next couple of moments, are there other decisions you think we should make as a necessity now, or will the other matters fall out as a matter of course when you go back to the hearing examiner's table to discuss the decision we make on this particular issue? Mr. Skaggs?
I think I just heard you say it, but to the extent that the commission determines, looks like it is, these were extraordinary, and there is that decision made today, we do think probably the necessary result of that is a remand to the hearing examiner for further proceedings, probably somewhat in his discretion for him to render a new decision in light of your determination that they're extraordinary.
Ms. Iori?
With all due respect to my learned colleague, no. You have found that you are not going to adopt his report, I assume, because he has found that they are extraordinary. That is your decision. Once the order is issued, then, depending on, I think there's still another decision you have to make, and that is whether, notwithstanding that the expenses are extraordinary, Delmarva's requested rate-making treatment should be approved. Once you make that decision, it is done. For all intents and purposes. Yes, there will be an order issued that reflects the commission's deliberations and decision, but that is it. It does not go back to the hearing examiner for a do-over.
Please, please explain the second part of your comments one more time.
This is not like on well, actually, not all appeals get remanded. I was going to say it's not like an appeal that gets remanded, but it isn't. It isn't like that because some appeals don't get remanded. The commission makes a decision, and right now, the first decision that you have made is that these are extraordinary expenses. In my view, the next decision that you have to make is whether Delmarva's requested rate-making treatment should be approved, notwithstanding the fact that you have found that they are extraordinary expenses. Once those decisions are made, and those decisions are put in writing in the form of a commission order, that is it. There is no remand. We don't go back to the hearing examiner to have another hearing on this. You have made your decision based on the record that was created before the hearing examiner.
Okay, how about this? Okay, we're going to make a decision, I believe, that the business judgment rule shouldn't have been used in the analysis by the hearing examiner. We believe he should have used ordinary expense, PRISM, as Mr. Geddes refers to the word. I'm not sure I understand why this tribunal cannot refer back to the hearing examiner to have him use that standard rather than the business judgment standard to review the decisions he's made and come with new recommendations to this commission. I believe that this commission may have some opinions that are different than what has been put on the table so far by the hearing examiner. And I believe that some of the commissioners may want those decisions revisited, or at least looked at, and then some decisions made. So you're not saying we don't have the power to remand it?
Well, I'm not saying you don't have the power. The commission can do whatever it wants, and we'll take that, as far as it goes, whether it goes up to the next level or not. But I think that it is not appropriate.
Commissioners, what's your thinking? She's being very nice. She just says it was inappropriate.
Mr. Chair, I would ask, if I could, if Mr. Geddes has a perspective on the question you just raised.
How many angels can dance on the head of a pin? I agree with Ms. Iori that the preferred course that we would support is to have the commission make the second determination, having found it, assuming that all five of you vote to find it an extraordinary expense, whether or not it should be recoverable. However, I would not want to sit here and say, or not say, something I've said many times to you before. You control your own dockets. You control what comes before you, when it comes before you, and I would respectfully suggest how many times it comes before you. Having said that, the DPA has taken a position, which I support, that it's unnecessary in this case to remand it, because we think that having made the initial determination, assuming that's the determination you made, that the commission has the information to make the second determination. However, I will say this, and this is a personal observation. I have tried for the many years that I've sat here to make sure that the commission has all the information it needs to make the most informed decision that it feels it can make. And if the commissioners feel that remanding this case to the hearing examiner under certain parameters that you may determine will help you make a better decision, I cannot say that I would not support that.
Well, let me just tell you my feeling on the situation. That is that I have, over the years, developed a lot of respect for all the parties around the table. And we have, I think, a decision coming forth that will change the hearing examiner's viewpoint with respect to the issues, and also change the party's viewpoint with respect to the issues. The parties have a long-standing relationship as adversaries that have gone through many a rate case, many a settlement, and in my opinion, have good judgment. And for those reasons, I feel that it would be more fair to the parties and to the consumers of this state if the hearing examiner of the parties were to give it another effort at either resolving the issues or having the hearing examiner write a new report based upon the new legal judgment made by the commission. That's my personal feeling. Other commissioners may not agree with that and may agree with Ms. Iori. So if, I guess someone's going to make a motion, and you can incorporate that if you feel that is appropriate in your motion, or you can just say, I move for Ms. Iori's position, and we'll go with that. Whoever wants to make a motion is free to make a motion.
So I make a motion that we decline the recommendations of the hearing examiner. However, we're not, at this time, determining whether there is recoverability of those costs in full under some other rule. Does that make sense?
And that we're remanding it to the hearing examiner for him to examine it on the appropriate, what we think is the appropriate standard. Some appeal court might disagree with us, and we're rejecting the business judgment
Right.
rule finding in this matter.
Right. So moved.
Second.
Is there any discussion on the motion? Is the motion clearly understood by council so that there won't be any confusion about the order? Okay.
Point of clarification, Mr. Chair. Do we put a time duration for having this come back to us?
No. The hearing examiner will set the parameters, and with the input of the parties with respect to their respective schedules, sometimes people have vacations and things of that nature. Plus, I don't think there's any immediacy with respect to this particular issue. Any discussion on the motion? All those in favor signify by saying aye.
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 Any opposed? Any abstentions?
I abstain, Mr. Chair.
One abstention. Motion carries. Thank you all very much.
Thank you.
Now, we're back to the regular agenda, number 2. In the matter of the application of Delmarva Power and Light Company to revise the utility facility relocation charge. We'll address proposed order number 9370. And we have Ms. Orr. Please proceed.
Thank you, Chair Winslow and Commissioners. Good afternoon, Lindsay Orr on behalf of Delmarva Power. You have in front of you proposed order number 9370, which would close the last two outstanding UFERC dockets, which are dockets 16-1083 and 17-0401. We thank staff and DPA for working with us to close these dockets and for staff's work on the memo and proposed order. We have reviewed the memo and proposed order and agree that they accurately characterize the agreements reached in these dockets. Accordingly, Delmarva respectfully requests that the Commission enter order number 9370, closing dockets 16-1083 and 17-0401.
Thank you, Ms. Orr. Mr. Willard.
Just to go over a couple of things. During the review of this, there were potential errors found on a pre-tax rate of return. And Delmarva made some corrections, et cetera. We have an agreement now after discovery, and there's been some underpayment, undercollection, and overcollection. And finally, there is an overcollection of $12,381, which will be included in the July 19 DSIC that will be filed by Delmarva. And we also ask that the Commission approve order number 9370. Ms. Knotts is here if there's any questions.
Thank you, Mr. Willard. Ms. Iori?
Thank you, Chairman Winslow. The Public Advocate supports the proposed form of order.
Thank you, Ms. Iori. Commissioners?
One point of clarification, Mr. Willard. Are you saying that in the order in front of us, the change is already made, or we're taking on an order that has been edited that we do not have yet?
No, you have the order.
Okay, good,
Yeah.
thank you.
A motion, please?
I move that the Commission adopt order number 9370 as submitted.
I second it.
Any discussion? Hearing none, all in favor signify by saying aye.
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 Motion carries. Thank you, Ms. Orr. I guess you're here on the next one as well, though. In the
Yeah.
matter of request for approval of Delmarva Power and Light Company's SOS rates, procurement, cost adjustment, and RORM.
Thank you, Chair Winslow and Commissioners. Lindsay Orr on behalf of Delmarva Power. You have in front of you for consideration order number 9371, which would open the docket for Delmarva's 2019 Standard Offer Service, Procurement Cost Adjustment, and Reasonable Allowance for Retail Margin Rates filing, and would approve the tariff rates set forth therein on a temporary basis and subject to refund following review and final approval by the Commission. I thank staff for preparing the proposed order and allowing the opportunity for comment. Delmarva is in agreement with the form of order that you have in front of you today and respectfully requests the Commission approve order number 9371 as submitted.
Mr. Willard.
Once again, this is just to open the docket, recommend approval on a temporary basis of the rates. And this is the case where Liberty already reported to the Commission that everything went well with the bidding process, et cetera. And we also recommend approval of the order 9371.
Thank you, Mr. Willard. Ms. Iori?
Thank you, Chairman Winslow. The Public Advocate supports the proposed form of order.
Commissioners, questions?
Move we approve the proposed order number 9371 as presented.
Second the motion?
Any discussion? All in favor signify by saying aye.
Aye.
Motion carries. Aye. Number 4, in the matter of the provision of renewable energy portfolio standards compliance charge to retail consumers in the service territory of Delmarva Power and Light Company. Proposed order number 9373. Ms. Orr.
Thank you again, Chair Winslow and Commissioners. Lindsay Orr on behalf of Delmarva Power. You also have in front of you for consideration today order number 9373, which would open the docket for Delmarva's 2019 Renewable Energy Portfolio Standards Compliance Charge filing and would approve the tariff rates set forth therein on a temporary basis and subject to refund following review and final approval by the Commission. I thank staff again for preparing the proposed order and allowing the opportunity for comment. Delmarva is in agreement with the form of order you have in front of you today and respectfully requests the Commission approve order number 9373 as submitted.
Thank you, Ms. Orr. Mr. Walsh?
Thank you, Chair Winslow and Commissioners. Ms. Orr's recitation is accurate. Staff has reviewed the application and the submitted revised tariff leafs, which Delmarva included with its submission and supports the temporary 2019 RPS compliance charge rate which would be effective on a temporary basis starting June 1st this year. And we have reviewed the attached notice, attachment A, which provides the deadlines for intervention, comments, and notes that a hearing will be set if any material objections or comments are filed. Staff supports entry of Order 9373.
Thank you, Mr. Walsh. Ms. Iori?
Thank you, Chairman Winslow. The Public Advocate supports the proposed form of order.
Commissioners, any questions?
So I move that we adopt 9373, opening the docket.
Second.
Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Motion carries. Hearing schedule, number 1, in the matter of the application of Delmarva Power and Light Company for approval of modifications to its gas cost rates. Before we get started on this, I just wanted to say something about Malika Davis here. I was really happy to see you in Columbus at the OPSI meeting last week, and it was a good thing. Hopefully you learned a lot, and I certainly appreciate you being there. But you know, when I read your background as part of your expert witness testimony today, I said, wow, I'd forgotten how impressive this person was. I'm not going to go back through your entire background and where you've worked and what you've done, but I just would just say thank you. It was very impressive, and so I'm sure that your credibility here today is going to be really pretty good. You're welcome.
Too bad our council won't be.
Who's leading off? Ms. Orr, I guess?
Thank you, Chair Winslow and Commissioners. Lindsay Orr on behalf of Delmarva Power in connection with its annual gas cost rate application. I am pleased to report that the parties have reached a settlement in this docket and have submitted a proposed form of settlement agreement for the Commission's review and approval. Preliminarily, the parties have prepared and stipulate to an exhibit log and ask that all of the exhibits on the log be admitted into evidence and adopted for the record, and I have copies for the Commission if I may approach.
Any objections? So moved or so entered into the record?
I
Oh,
just have-
objection, uh-oh.
No, it's not an objection, just an addition. For exhibit number 3, which is the direct testimony of Jerome D. Mierswa, that is sponsored by both staff and the DPA. Thank you. And the exhibit log only says staff, so I just wanted to make that, with that one correction, we have no objections.
Off the record, that's a Delmarva mistake.
Well, I think that the testimony itself makes it clear that it's both parties.
Just kidding. I didn't pick that up.
I apologize for the oversight. I have with me Jim Jacoby, who will serve as Delmarva Power's witness to provide testimony regarding the settlement. May he be sworn in?
Please raise your right hand. Do you swear that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your name for the record and spell your last name.
James B. Jacoby, Jacoby.
By whom are you employed and in what capacity?
I work for Pepco Holdings, Inc., and I'm the manager of gas supply and transportation.
And how long have you held that position?
8 years,
And how long have you been employed by Pepco Holdings?
29 years.
What are your duties and responsibilities in your current position?
I'm responsible for developing and managing a reliable and cost-effective gas supply portfolio for the Delmarva gas customers.
In connection with the proposed settlement of this docket, were you involved in the filing of the application, the preparation of testimony, and the settlement discussions that took place?
Yes,
Did you prepare testimony for this application?
yes,
Did you review the testimony of the other witnesses in this application?
yes.
Do you have any changes to your testimony or to that of Delmarva's other witnesses?
No.
Do you adopt your testimony and that of Delmarva's other witnesses?
Yes, I do.
Can you outline the specific terms of the settlement agreement?
Yes. There's 3 primary provisions that I'll talk about today. First of all, the parties agreed to implement rates as filed, which will result in a rate decrease for our customers. For a residential space heating customer that uses approximately 83 CCF per month of gas in the winter, they will see a decrease of $5.65 a month, or about 5.8% of their total bill. For customers served under the GG classification, they will experience a decrease on their bill in the range of 2.3 to 7.8%. MVG customers will experience a decrease in their bills in the range of 7.1 to 10.5%. Second provision that was agreed in the settlement agreement is that Delmarva has agreed that we will not be renewing two firm transportation contracts that we've had in place for about 20 years with Columbia Gulf Transmission. That's contracts 80726 and 80727. Third and final provision is that Delmarva agrees that we will continue to prevent the return to sale service of customers that are non-core or transportation service customers who have left but wish to return to service until we restore the capacity reserve margin to over 2%. This has been in place, I believe, for the last 3 years and will remain until we put in place additional supply opportunities.
And in your opinion, will this settlement provide for just and reasonable rates for customers, and is it in the public interest?
Yes.
And why is that?
Entering into the settlement avoids the cost of and use of resources associated with litigation and amicably resolves a number of issues that were raised by staff and DPA during the proceedings.
Thank you. Mr. Jacoby is available for a cross-examination.
Any questions, Mr. Geddes or Ms. Iori?
No questions.
No questions.
Are you related to Joe?
I wish I was, but no.
He should be in the Hall of Fame.
I would agree.
For the state, who's going to proceed? I guess that's your only witness, right, Ms. Orr?
Yes.
We're still trying to figure out your last question, but anyway, we'll proceed.
Joe Jacoby, tackle, offensive tackle,
For the Redskins.
or the Hogs?
Right.
Yep.
Right, he was one of the hogs.
Yep.
Hogettes. Now hogs.
I'd like to call Malika Davis to the stand and ask that she be sworn, please.
Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? I do.
Could you state your full name and business address for the record, please?
Malika Davis, 861 Silver Lake Boulevard, Cannon Building, Suite 100, Dover, Delaware, 19904.
Excuse me, could you use a microphone a little closer? Thank you.
And by whom are you employed?
Delaware Public Service Commission.
And what is your position with the commission?
I'm a public utility analyst.
And in connection with your employment, have you performed certain review and investigations in this docket?
Yes.
And as part of your duties and responsibilities, did you pre-file testimony on January 7th, 2019 on behalf of the commission staff?
Yes.
Did you prepare this testimony yourself?
Yes, I did.
Do you have any changes, modifications, corrections to the testimony that you pre-filed?
I do not.
If I were to ask you the questions set forth therein, would your answers be as recorded?
Yes.
Do you adopt this as your pre-filed testimony in this proceeding today?
Yes.
Is it also correct that staff, along with the DPA, retain experts for this docket?
Yes. We retained Mr. Jerome Muir as well of Exeter Associates.
And did he assist you and the DPA in the review of the docket?
Yes.
And in connection with that review, did he pre-file testimony on the same January 7th, 2019 date?
Yes.
Do you have any changes, modifications, or corrections to his testimony at this time?
I do not.
And do you adopt Mr. Mirzawal's testimony as your testimony for this hearing today?
Yes.
Might we have might we have Ms. Davis's testimony marked as Exhibit 2, Mr. Mirzawal's testimony Exhibit 3, and I request that they be entered into the record.
Without objection, they are entered into the record.
Did you also, Ms. Davis, participate in the settlement that was discussed previously by the Delmarva witness?
Yes.
And could you, do you believe that the settlement that was reached between the parties is in the public interest?
Yes.
Could you please explain your reasons for why you believe the settlement agreement is in the public interest?
Yes. Staff reviewed the application and the supporting documentation that was provided by the company. Staff found that the proposed GCR rates are just and reasonable, and that they were calculated correctly and in accordance with the company's tariffs. Additionally, the settlement incorporates the suggestions made by staff and DPA's consultant regarding the termination of its firm transportation contracts with Columbia Gulf, which we believe are no longer necessary to meet the requirements of Delmarva's firm gas customers. And the settlement also maintains the provision from the last settlement agreement regarding Delmarva's capacity reserve margin and additional upstream capacity.
Thank you. Is there anything further that you believe should be brought to the attention of the commission before they consider the settlement agreement in this proceeding?
No.
Thank you. I have no further questions for the witness. She's available for any questions the commission or other parties might have with regard to her testimony.
Are there any questions of Ms. Davis?
No, Your Honor.
No, Your Honor.
Commissioners? No questions from the commissioners.
That completes staff case. Thank you.
Thank you. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. We do not have a witness. We do obviously support Mr. Muir's testimony. We believe the settlement is in the public interest and executed it with that belief, and we would ask the commission to approve it. Thank you.
Thank you, Ms. Iori. Commissioners?
Mr. Chair, I move that the commission adopt the settlement agreement as presented.
I second.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Motion carries. It's 5 ayes.
Thank you.
There's public comment at this time. I see we have some members, I believe, of the public here. Does anyone would like to make a comment? Demi, you want us to make a public comment? Demi also, I'll make a public comment. Demi also was in Columbus. We appreciated his presence and his work. And we're all trying to learn a little bit more about PJM, and that's a good thing. And we have nobody coming forward to speak from the public, so we'll go on to our, I meant to say this, I guess, maybe I'm out of school right here, but I guess we're going to talk to the executive director, who will always in the future ask both sides before he grants a continuance.
Well, thank you, Mr. Chairman, Commissioners. I was going to bite my tongue, but since the better-looking Dr. Borrow of our household is not here, I guess I can go in and say it because she gets nervous when I open my mouth. I was not going to say certain things. I was going to bite my tongue, but what the heck, let it go. Thank you, Ms. Iori, for talking to your kind words. I really do appreciate it. While some parties have mentioned about my partiality, I try to strive to be impartial to the extent sometimes I think I disfavor staff actions. But be that as it may, on that docket that you just acted on, I did have a quick talk with Mr. Goodman, and I'd like all those parties here to know that the reason I strive to get material to you 2 weeks before, because that was a desire. And also we try to get draft orders a week before. So in this case, we have 2 weeks from now to the next meeting when the order memorializing what you just did will be before you. And I want a commitment from all the councils here that we will have the draft order ready by next week so that we can send it to you a week before. Because there's a lot of nitpicking going on in the last minute. What parties don't realize is my compadre here, Matt, and I voluntarily, not looking for kudos, but stayed back yesterday just to make sure that those things were filed and got to you yesterday. So it's not that we don't try hard, we do try hard. But, be that as it may. I learned those words from Mr. Geddes.
Excuse me, Mr. Goodman?
Yes.
Did you sit there for a reason? Do you want to speak?
He said he wanted to
The
get a
the
commitment from
commitment.
council, so I thought I should come up here
Oh,
to
okay.
put that on the record since he's asking for a commitment.
Okay.
Thank you. You have an evidentiary hearing before you in the next meeting on May 7th, which is your next meeting. It's PSC docket number 19-0080, Delmarva Power and Light, 2019 program for the procurement of solar renewable energy, here at 1 o'clock. The next commission meeting is May 7th. I do want to make a schedule change I know this is way ahead, in a September commission meeting. I would like to move the commission meeting of September 24th to the commission, to Thursday, September 26th, because you commissioners have the macro only commissioners meeting from September 22nd to the 25th. Is that okay with you? I don't know where it is though. I had no idea.
West Pagada.
I had no idea.
Yes, we,
Oh,
yeah,
You're
we-
okay with
we-
the change?
We're very fine with the change.
We did file with New Jersey Commission and with the New Jersey Board and Pennsylvania Commission in the FERC filing that you had also said yes to the OPSI filing on the IME market monitor's complaint against PJM at FERC. Dimi had prepared a memo, and I'm not going to call on him, but we placed the memo on your desk for you to read the summary of the filing. And I think that's all. If you have any questions, of course, you know where to get hold of Dimi. With that, I have no other comments. Do you have any questions for me? If not,
No,
yours.
no. Thank you very much. Everyone have a safe trip home, and thank you for being here.